Hello and welcome to Profiles in Leadership. My name is Daryl Lim, professor here at Penn State Dickinson Law, and today I'm pleased to be joined by Roberte Makowski, who is the Chief IP Counsel at FMC Corporation. Welcome, Roberte, and tell us first of all about your early life and education, where you were born, where you went to school. What did you take away from those years?
Well, first of all, thank you, Daryl, and Happy New Year. Appreciate the opportunity. I'm originally from Canada, and I was born in Winnipeg, Manitoba. Didn't stay there very long. I think before my first year, I had already moved to Toronto and then Ottawa. My parents were originally born and raised in Ottawa, so we did move a lot, but we seemed to always come back to Ottawa. I have lived in, Montreal and did my high school in Quebec City, but then moved back again to Ottawa, where I did my undergrad in biology, master's in entomology, and then worked for the Canadian Department of Agriculture for a few years before then, meeting my husband and moving out west to Regina, Saskatchewan. And there I continued on and did my PhD in agriculture at the University of Saskatchewan. So that's my early years. What I've learned through all those moves and different areas of education, I think a lot of it was basically learning how to be adaptable and flexible. Change is never easy for anybody, but having moved a lot as a child, I think that sort of said, okay, we're off again, and make new friends and adapt and just be flexible. And I think that served me well later in life and through work and with our changes certainly in our lives in the last few years with the pandemic and all these things that has served me well to be able to do that. And I think all of that early moving and has taught me that or allowed me to be that, have that more flexibility, certainly.
And FMC, of course, is a major player in the agricultural space, but your journey in agriculture actually started fairly early on too. So tell us about how you got into agriculture and how that eventually led you on that path to FMC.
Yeah, so it's probably not something I had thought about, early on, but going through biology, I really enjoyed the sciences. So in, taking biology, I took all kinds of different classes, and I had one professor in particular who was a great mentor. As you know, being a professor, you can shape a student's sort of path and inspire them. And so one of my professors had a grant. I always wanted to do a master's. I knew I would do that at some point. And he had a grant from the Canadian Department of Agriculture for a student to do work in pollination ecology in apple orchards. So it was with the Canadian Department of Agriculture. And so, I took the opportunity as it presented itself and then just went from there. Continued on after my master's, working again with the Canadian Department of Agriculture for a few years before then I went off and did my PhD and continued to work for them. So it sort of evolved almost naturally by embracing the opportunities that presented themselves. And I do very much enjoy working in a field where it has such a great purpose, I guess, in life. We're trying to feed the world, right? We're trying to provide solutions to growers and farmers to eventually feed the world. We always have to eat. So, being in agriculture, also sort of motivates me in that way, as well as trying to help society.
That's a great tagline. In fact, one which I think I'll use for this particular podcast, Feeding the World. And I think it does encapsulate what agriculture is all about, and
Mhm.
how FMC is making it more efficient and effective in us doing that. You were in Canada, you talked about adaptability, which of course is a huge part of leadership and organizational leadership as well. And you moved from Canada to the US, which again requires some adaptation, even though the US and Canada are quite similar. But perhaps it's the differences that people sometimes overlook that I think our listeners would be interested to hear about. So why the US, and what were some of the differences that you have noticed between Canada and the US?
Yeah. So we moved to the US for my husband's work. It's always challenging to have a two-career family. And, these decisions are not made lightly. And really, it's a family decision on these types of moves. And he had a great opportunity here in the US. And I was at a point in time in the project I had been working on for almost 10 years, that it came to sort of, a good transition point. So I was able, thought that it would be a good opportunity for me as well, and for the family. So we moved to the US, and that's when I actually decided to, had to start over. So I started teaching, and really, really enjoyed that. But yes, as far as the differences between Canada and the US, you're right, on a daily basis, and work and where you live and the types of foods you eat overall, generally speaking, it's pretty similar. I think a lot of the difference between Canada and the US is maybe a bit on the cultural, social side of things. I guess that is probably the biggest difference. Canada has, universal health care, and has had it for a very, very long time. There's just more of a multicultural approach to the culture, and probably a little bit more on the social consciousness side of the culture. Certainly some language colloquialisms are a little different depending where you are. The banking is incredibly different between US and Canada, if you want to get into some of these different areas. But I think more of the culture, I think, is a little bit different. There's a lot of similarities, but there are clear differences. Canada, in many ways, is similar to Britain. It's part of it's a Commonwealth country. So there are some roots there that are maybe more obvious in Canada than they would have been in the US.
And let me ask you something about social consciousness, which you mentioned. How has that affected, you think, the way that Canada approaches, say, agriculture compared to the US?
I think a lot of similarities. I mean, as far as agriculture goes, I mean, there's a lot of subsidies as well, as much, many in the US as well as in Canada. Again, I think in many regards, it's quite similar.
So what is different then about when you talked about social consciousness? What did you have in mind?
Yeah, not so much with agriculture. I think it's more just taking care of people in a very different way. There's more government involvement, I think, again, in things like healthcare, and that kind of social consciousness, right, is here. I think, generally speaking, folks don't want to have too much government interference in their daily lives. There's maybe more of that acceptance of government not will take care of us, but will work for us. And so it's just a slightly different approach on, gun laws, for example, are incredibly different between Canada and the US. Again, the more the individual rights versus a community right. So maybe a little more, on the social side versus how US views things. So that's the cultural difference, yeah.
And just looking ahead then into IP more broadly, would you say that IP is different in Canada compared to the US, or would you say just like agriculture, it's very similar?
I think it's pretty similar. There's a lot of harmonization in IP laws globally as well. There's still differences country by country, but overall, I think IP laws, they're more, federal if you want, and they're more, a lot more harmonization, I think, certainly on the trademark side. Patent side is quite similar. There's clearly nuances in the patent laws, but they are very similar.
And you talked about being a professor.
Mhm.
Why did you get into it, and why did you get out of it?
Well, even as part of being a scientist with the Canadian Department of Agriculture, I mean, we always worked very closely with the growers, and we were trying to do, cutting edge science as well, but trying to come up with solutions for them. And so we are, had farmers field days, we had grower days showing them what we were doing and, really interacting with them a lot. So in a way, there was a lot of education there and a lot of teaching as well. So, and I did, during my studies as, master's and PhD, did some, TA, right? Teaching assistants, and truly enjoyed that. I ran the biology labs for a while, at University of Ottawa, or did a lot of the biology labs there, and really enjoyed that, first year biology. And so I thought when we moved to the US, that would be a good opportunity to continue that. And I really do enjoy teaching. And it has served me well. So I started when we moved to the US. I taught a few classes at University of Delaware in agriculture and weed science, and then full-time at Wilmington University, where I ran the science program, which is all a program for non-majors. So again, that has served well, is trying to teach complex scientific, concepts to people who don't know much about science at all. And that serves well in the law. And it continues to serve me well in the sense that, patent law is complex, trying to explain that to the business folks, just like, trying to teach complex science to non-majors. And also with patent law, when you're trying to get patents, doing patent prosecution, you have to explain patent law to examiners at the patent office who don't have the legal background. And also they don't necessarily know the cutting edge technology you're trying to get protected. They all have a technical background, but it's teaching them this specific thing. So there's a lot of that education going back and forth. So I do enjoy teaching very much. And you do it constantly as a lawyer as well. If you're in front of a court, you have to explain all these complex science and patent law to, judges and juries, so same skills that you learn as, when you are teaching, you use constantly within the business with, other lawyers who don't understand the technical part as well. So it's something we continue to do constantly.
I think that's such an important point, and one which certainly my students coming into law school often don't appreciate at the start, but most of them do by the end, is that being a leader and being a professional, being a lawyer, involves quite a bit of teaching. And as you had mentioned, especially in patent law, where you are really straddling between two disciplines. There's a lot of interpretation and simplification and communication that goes on. And it sounds like your time as a professor, even before going to law school, which we'll get to in a moment, has ingrained that skill set in you. But the journey continues. And so
Correct.
go to law school. Reflect on that time and tell us about some of your takeaways from those years.
Yeah, so as I say, I really enjoyed teaching and was certainly going to continue there for a while. But then again, we had another family move. And that's when I decided, I had thought about law school. I had some, even back when in undergrad days, I had some fellow, student, colleagues there who did go on to law school. And I thought, oh, that's interesting. I could use biology, get into environmental law or something like that. But all these other opportunities presented themselves. So once we did that final move, I figured it's now or never. And really the biotech was coming on, into its own at the time. I had sort of been exposed a little bit to licensing. And so I thought, oh, this is something, I always aspired to do at some point, and that was the perfect opportunity. So we moved to North Carolina for a couple of years, and just to make sure, IP law, which with my background made perfect sense. I did audit a class in IP and at UNC, and thought, yep, this is really interesting. This is what I want to do. And then ended up doing my first year of law school in North Carolina. And then again, we were transferred back, to Delaware. So I continued on then at Villanova, and never looked back. That's been, almost 20 years now as well. But it's been a great decision, and I truly enjoyed the combination of still doing science, not at the bench doing it anymore. Knew I wasn't going to do that the rest of my life, but just really being with some very smart people. The R&D folks are cutting edge science, and you're there helping them out, protect those inventions. So it's really, a great combination of the two fields.
And how much of what you learned in class in law school, in IP law otherwise, do you continue to use today?
You learn the basics. You learn some of the, the court decisions that formed, the law that we practice today. But you really learn on the job. I mean, there's no, most law schools, I think a lot of it is a little more theoretical, unless you're into, practice. One area, though, I did have the opportunity in law school to do a judicial externship, and worked with one of the federal judges here in Delaware, the magistrate judge, who was amazing. And that was a great opportunity to really be involved in court, and decisions coming out of the court. And that was a great learning experience. But you really learn how to practice when you're doing the work itself, not as much in law school, but it gives you the strong basis that you need to be able to spot issues, ask the right questions, and so on.
So would it be fair to say, if I understand you correctly, and this I think would be of great interest and perhaps great surprise to our law students, is it's not so much what you learn in terms of the black letter law and the cases and the statutes, but how you learn. You learn to learn. And really you learn the culture, as you say, the research and the experience that really defines you as an attorney.
Yeah, correct. And it really teaches you how to think as a lawyer, not so much, the practical things you're going to be using every day in when you're practicing, but it allows you to have that thought process, the issue spotting, the, learn how to, delve into the research and come up with, some advice that you are, some good advice, hopefully, and help you do the risk assessment, which is really what the client ends up needing in the end is, if I do this activity, am I going to be infringing somebody's patent, or, or what is the risk of it? What are the chances of success if we go to court? Those kinds of things, and really detailed evaluation of the law, and in IP of the science as well, and being able to spot the potential risks, issues, to help the client, do that risk assessment before deciding how to proceed.
And so that brings us nicely into the next stage of your career, which is practice. How many years were you in practice?
So it's almost 20 years, I guess 19 years now
altogether.
In
a law firm.
Oh, in a law firm. So when I graduated, again, I mentioned that it was a lot right when biotech was becoming, into its own. And so I was very fortunate at the time to have several offers because with my biology and biotech background, that was well sought after. I chose to go to Conley, Bove, Lodge and Hutts, a Delaware IP firm, had broadened a bit into corporate law as well, but mainly started as an IP firm and well recognized as an IP firm. And I chose them because of the depth of knowledge and the depth of experience of the patent attorneys that were there, and they did patent prosecution, opinion work, as well as litigation, patent litigation. So a real breadth of, experience. And they'd been around for a long time as well. A lot of attorneys had been there for over 20 years. So you really got to have great mentoring. I think that's a critical piece when you choose a law firm, do they have that bench of experience, and then are they great mentors? Will they really teach you how to practice and how to think and how to, learn your craft in a way. And I did have great mentors. I made partner in 6 years and just had some great clients as well. And, they really taught me how to be, I think, a very good attorney and how to practice and the complexities of patent law. The science I had, but it was just now applying it. And that was great. So I was there for about 8.5 years. And again, with the 2008, 2010 period, a lot of law firms were going through difficult challenges. The firm was evaluating whether it was going to merge or how it was going to, continue in the future. And at that point, I decided to go in-house.
And before you go there, I want to ask you something about being a woman in practice and a scientist in practice. Did you feel that gender was at all a role, whether for the positive, negative? How did it affect your time in practice as an IP attorney?
So on the science side, I must admit that certainly in undergrad, master's in Ottawa, I had a lot of women professors, so I never really felt a problem or any issue there. Getting into agriculture was a little more difficult. It wasn't a lot of women back then, and certainly not, PhDs in agriculture. We were still several of us, but research scientists, even at Agriculture Canada. I was the first woman at our research center in Regina. you'd go out to the field with growers, with a group of people, and, they thought I was more the technician, not the lead scientist. So there was a bit of that. I mean, it certainly has progressed a lot better now. There's a lot more women in agriculture, but still it's fairly dominated, I think, by men, but I think that is changing. As far as law goes, I don't think I felt that. At our law firm, the hiring partner was a woman. She'd been there for 20 some years. So there were, in our class in at Villanova, I think was almost half and half. So I didn't feel, much challenges on that front. On the legal side, we were given opportunities, again, based on, our performance and our merit. So I didn't really feel that so much in the law side.
Thanks. So you were going to talk about your transition into going in-house. And I'd like you also, as we talk about that, to reflect on what many folks in practice sometimes don't appreciate, which is that when you are in practice, you are a revenue generator. And you bill and you bring in that revenue. But when you are in-house, you are a cost center.
Correct.
And that changes the dynamics. But how does it change the dynamics? And what do you wish folks in practice appreciated better about when dealing with in-house counsel?
So if you're, if you're at the law firm and you're dealing with in-house, larger companies, not startups, that's a little different because you're sort of, with a startup, you're sort of their legal counsel, right? There's not really in-house folks there necessarily. But if you're dealing with a larger company, which I was, my clients were pretty large companies, you only deal with in-house counsel. You rarely deal directly with the inventors. Occasionally you may, yes, but a lot of times, your client is the in-house counsel. And so it's really trying to put yourself in their shoes and trying to understand what it is that the company is looking for, what is the end result of, the ask that they give you. You're really working on very discrete projects, right? When you're at a law firm, it's whatever the in-house counsel or your client is giving you as a project that they want an answer to. So you have to sort of try and understand what their goal is and what the end result is that they are looking for, your advice on. And so but then the project is done. It's a very discrete project. In-house is very different. You are much more a partner to the business, to the R&D folks. You get a much broader big picture, which is what attracted me to go in-house as well. But you're juggling so much because you do not just this one project. You have you're pulled in 100 different directions, by the R&D folks, by the business folks who, want agreements or, or can we do this activity? So we need this FTO right away, freedom to operate opinion and evaluation, making sure we don't infringe somebody else's patents. And you're being pulled in all these different directions. So it's really, we look to outside counsel to help us, with these discrete projects that we just don't have time to do. So when you're in the law firm, you want to be able to at least deliver what it is they're looking for and putting it in, as in the right format with the right type of budget as well. We're always conscious of budget, but it's also, explaining in detail what your work as outside counsel entails and putting it in enough detail so that they can evaluate that, okay, yeah, if you have to do all this to get to that answer, it's going to cost this much. Now I understand. If it's just oh, it's going to cost you, I don't know, $10,000 to do this. Well, I need more explanation in-house to understand that cost benefit of giving you that work.
How important is space time? Say, whether it's time on the golf course or time at corporate functions or even reading a company report. How important is it for outside counsel to have those types of connections and understanding in order to be an effective outside counsel?
Yeah, I think I think things have changed dramatically from maybe 15 years ago. Golf courses, relationships, I haven't seen a whole lot, and I do play golf, so I think that has changed. I mean, we do occasion, there's much less of that, how would I say, entertainment type of connections and relationships than there used to be. And certainly the pandemic didn't help that, right? We do certainly have the occasional lunch and or maybe a dinner once a year with certain counsel. But it's not the same kind of, oh, let's go play golf every Friday or, once a month or things like that. I just have not seen much of that. Again, it's time is of the essence for in-house folks. They're incredibly busy. It's not what it used to be either, where I remember people saying, oh, it's going to be 9 to 5 and you just farm everything out to outside counsel. Well, we don't have unlimited budgets, so we can't do that. So we also work just as much in-house as we do at a law firm. But we do still try and develop strong relationships, and a lot of it is based on, the responsiveness when you're at a law firm and your client contacts you even via email. They want to know that you got that email. They want to know that you're responding, that you're paying attention to them, no matter what size of client you are. So responsiveness is critical. Pragmatic advice, just high quality product in the right format that the client needs. Sometimes when you're doing an evaluation of freedom to operate, let's say, which is evaluating, another, whether there's patents out there that, based on your activity that you may potentially infringe or not, you can have, maybe for this project, it could be very short. All you need is just a quick summary memo. In other cases, you want a full-blown detailed opinion so that it protects you down the line from, being sued. So again, understanding the need of the client and producing the quality product in the format that they need. And quite often you may not even do a writing. They want to just have an oral evaluation to start with before deciding to pay for, a full-blown opinion. So I think it's keeping that responsiveness and that dialogue to clearly understand the client needs, I think is what's critical when you're at a law firm.
I want to talk a little bit more about responsiveness, because I think responsiveness is sometimes an asymmetrical concept. When you see it from the in-house counsel's point of view and you see it from the outside counsel's point of view. I hear, especially from young lawyers, a lot that their partners expect them to respond after hours, on weekends, sometimes even on vacations from the airport, because they say the client expects it. Now, does the client really expect it? And do they expect it to the degree that they seem to be thinking that they expect it?
Yeah, that's a really good point. I mean, it's there are times where, I just got sued. I need to know what's going on. I mean, those kinds of things. There are some critical times when things are moving very fast. If it's in court or there's deadlines coming up, you really want to know they're on top of it. But, generally speaking, you can manage expectations as well. So if I send, an email, I usually try and be respectful of people's weekends and evenings. But if I send an email to a client, for example, or sorry, to an outside law firm and ask them, listen, I have a new project, when do you have time to talk about it? Here's my available times. And then, so I do expect, yes, I got your email, this time looks good. And that's it, right? But that doesn't have to be at midnight or 3 a.m. It can be either, later that day or the next day is fine. Usually, try and accommodate and give number of times because they may be in court, they may be doing other things. So, so I don't expect that, right away. The other piece is, again, it depends on the project. If you're in the middle of a litigation and things are happening fast, of course you expect them to let you know what's going on as soon as it happens. But again, if you're at the law firm, you can also say, got your email, let me get back to you tomorrow or the next day, just so that the client knows that you got the email, but that you're going to provide some more information or on Monday, not on Friday, or you can manage those expectations.
Thank you. That's very helpful. So let's talk about FMC. And on the same note of information, what should folks know about FMC and IP at FMC in particular?
So FMC is a company that's been around for over 100 years. It started off as, I think it was called Food Machinery Company, and it actually had developed a sprayer for spraying, in fields, or I think in orchards actually. And then from there, it evolved. It had, many different areas of chemistry as well. And I think one of the bigger changes recently happened in 2017, where they bought a substantial portion of the crop protection business of DuPont. So DuPont and Dow were trying to merge, and the EU Commission, so the European Commission for Antitrust, said, we don't want to lose a key R&D player in agriculture. So if Dow had a R&D, DuPont had R&D, if they merged, then you only have one, not two. So they didn't want to see that. So they really said, one of you have to decide you're going to divest an R&D group so that we continue to maintain, a number of key innovators in the field. And so that's when, DuPont decided to divest, again, their large portion. FMC did not have R&D at the time. They had in the past, but had gotten rid of it, in the ag field. They had other areas, but in the ag field. And so, that worked out well. FMC got not just, patents and things like that, but they got scientists, they got facilities, they got production plants, because they, again, the EU Commission wanted to make sure it wasn't just, theoretical sale of R&D, but it was up and running and working and truly an acquisition of an R&D organization. So FMC bought, acquired that very large portion. With that, at the same time, actually, FMC had a health and nutrition group. They sold that to DuPont. So, and then what was left then of FMC at the time, they also had a lithium battery business, and that was in the works of being spinned off as well. So in 2019, they spin-off of that area. So it's called Livent is the company, and that was spinned off. So then FMC is strictly only an agricultural science company today.
And tell us about who FMC's competitors are. How does IP feature into FMC's comparative advantage when it comes to that competition?
So we are within the top 5 agricultural companies globally. So, there's the BSFs of the world, Bayer, Syngenta, Corteva, which is DuPont's, crop protection business. They still have some, and, with Dow as well. So that now has become, they're called Corteva. So we're amongst that big 5. We're not the biggest, clearly, but we do compete in that space. A lot of the technology and the products and the IP that we got from DuPont are really crown jewels. I would say especially in the insecticide area, there's 2 main compounds that we acquired, that one of them, the trade name or trademarked name is Rynaxypyr. The other one is Cyazypyr. Those active ingredients, the Rynaxypyr was the first billion-dollar insecticide globally. So it's has very low mammalian toxicology. It's very effective against mainly lepidopteran pests, which are, your worms that eat things and moths type area, but they are effective against a number of insects. So that was, a very large purchase. And so, again, so we compete in that space with these other companies. And we got a lot of IP with that as well. And we continue to expand that portfolio. IP is a really critical piece of FMC. They really value IP assets because they understand that it allows us, to better compete and, push off generics. I mean, we spend tremendous amount of money in R&D, and we have a tremendous pipeline of molecules, not just synthetic chemistry, but biologicals as well. There's tremendous investment in R&D because that's our future, right?
When you talk about generics, how easy is it to reverse engineer what FMC has done?
So when you have a synthetic product, it's again, there's been a lot of patents out there about various portions of how you produce the active ingredient. It's a complex process for the diamides, these 2 molecules I talked about. Some of the processes can be straightforward, others can be quite complex. Some are protected by trade secrets, some are protected by patents. Not always easy to reverse engineer, but on top of just producing an active ingredient that then needs to be formulated so that you can actually apply it to the field and it works, you have to register it. So this is a highly regulated industry, very similar in a way to pharmaceuticals that are highly regulated. But on top of just making sure that these products, do what they're supposed to do by killing pests and protecting crops, they have to be safe, right? Safe for the environment as well as for the grower who's applying it, right? And the applicator, and has to have minimum residue if it's going to be used on crops for food, so that you're not ingesting this. So you have the regulatory framework for agricultural products is in a way much broader than just human toxicology and mammalian toxicology. We have to do all these environmental studies, bees studies, non-target organisms, fish, their how long will they last in the environment. All of those things are part of submitting a regulatory package to the authorities in every single country to be able to get, your registration, which then allows you to sell the product. You can't sell a product without a registration. So it all ties together, that IP is such a critical part to protect your investment in R&D for the long term, so that you can actually get a product to market. And then by then you don't have a whole lot necessarily of patent term left. But the company feels that it's, because of such a high investment in R&D and regulatory, comes with that the investment in IP.
Now, you talk about generics. Where are most of these generics coming from? Are they local? Are they international? And so which countries?
So I would say most of our generics at this point come from India and China. Those are the two big areas where you see generics. And that's the same in pharma as well, right? Yeah.
Do you find it challenging to enforce it? Do you enforce it there in China and India, or do you enforce it here, say with the ITC, and you prevent imports?
So it's, we try, and again, every company has slightly different strategies on their enforcement. We try and enforce against the source. So that's China, India at this point. We have a lot of litigation going on in those two countries. We have been successful in some, and not in other cases, right? But really have had good successes of suing generics who want to come into the market prior to patent expiration. And so we have had, several very good successes in both countries, but also some drawbacks. It's a big challenge where there, you see some local protectionism because, they're generic companies there. It is definitely a challenge. And I think one of the bigger challenges is also with, patent offices understand the science, so that's easy enough. They may not understand the patent law completely, but they certainly understand a lot more on the science part. What's hard when you get to court, it's the judges don't have the technical background necessarily. And again, there's where your training comes in, teaching and that kind of training. That is, I think, one of the biggest challenges, is explaining the science, and as well as patent law. If you have a judge who doesn't try very many patent cases, it's hard for them to understand the nuances of both the technology as well as the science. So that is also a real challenge in those countries. But I think, as I say, if you get a judge who has had many patent cases, that's very helpful. If not, then it is a real challenge. There's no question, and you do see some protectionism.
So you are chief IP counsel.
Mm-hmm.
So you have a team. Do your team members ever call you chief?
No. No. No, we have a very, I would say, collaborative group of folks, highly experienced, and really great team of IP attorneys, patent agents, patent paralegals, as well as trademark paralegals. So our team is responsible for everything IP for the company globally. So we deal with patents, we deal with trademarks, trade secrets, and copyright. the main key for. Patents is certainly, complex, and a lot of it, we have, as I say, we actually have 5 patent agents who are responsible, and they do the daily, as we call, preparation, drafting, prosecution, and manage the portfolios globally. I mean, we have a very large portfolio. I think this is in our annual report too, we have, over 3,000 active granted patents globally. We have over 1,700 pending patent applications globally. So there's 5 patent agents who manage all of that, which is a lot. And then the patent attorneys, we also have 5 patent attorneys, and they have both regional and global responsibilities. So we have, and we have it by what we call indication areas. So we have on the insect control side, the weed or herbicides, and then fungicides is another area, and then biologicals. So again, the IP attorneys do less of that daily prep and process, we would call it, prosecution, obtaining patents, dealing with the patent offices, but they deal more on the strategy, overall IP strategy, and we do a bit of everything. And that's one nice thing about FMC, if I really enjoyed, is the fact that we do such a breadth of legal work. So certainly we work with the patent agents on strategy, filing strategy, et cetera. And then, but freedom to operate opinions, we deal with the business and the R&D community, but also the marketing group, and who want to go, let's say, into a new country where they never sold this particular product before. And, can we even go there? What are the, and then all the agreement work that comes with that. So we deal with all types of agreements, not just the more IP ones, confidentiality agreements, material transfer agreements, but we also work very closely with our commercial lawyers who do all the, supply agreements, distribution agreements with third parties. There's always some IP in every of those agreements that we get involved with. We do a lot on the collaboration partnerships with third parties. And again, that's always huge IP focus. And so we're involved in all of that. And then also, as you mentioned, the defense and enforcement. So we do the gamut of work, which makes it really challenging, but also very fulfilling and very interesting to have that breadth of work. Mm-hmm.
Thank you. I just want to check that you don't have a hard stop, because there are a few more questions I want to ask you about managing your team and working at FMC, as well as current developments that I hope that we can cover.
Sure.
Thank you. So talk to us about how you manage your team and how you manage upwards too, because you have the C-suite as Chief IP Counsel, you are reporting to the C-suite. So tell us about how you, as a leader, manage both up and down.
So I really try and build a one team approach. We work incredibly collaboratively. So as I mentioned, if we have both regional and global responsibilities. So I have, one IP attorney who's in Denmark, who's responsible for our plant health business. And but if all of a sudden they want to do an activity that involves an insecticide that one of the other IP attorneys is responsible for, they work closely together. So we always are interacting together, and that's really the culture that I like to develop. Open door policy. We're here to come up with the best solutions to allow the business to do what it needs to do. And so we work very collaboratively. The patent attorneys report directly to me, so all 5. The patent agents report to patent attorneys, and the paralegals report to one of our patent attorneys as well. So I have weekly meetings with my direct reports, so the 5 patent attorneys, and then we have monthly meetings, the whole team, where we go through, all the issues or new developments or things like that. So again, very collaborative approach. And we always have ad hoc meetings if we're on a project together. We meet on a regular basis as well. And with the upper management, again, we have, monthly meetings, the whole law department. And I have, one-on-ones with our general counsel, again, once a month or as needed, again, if we're working on a project, or if we, as far as the, capturing innovation, getting our patents, the strategy around that, we take care of that ourselves. But when we get into litigation and where there's going to be, some risk potentially to the company, or if there's a huge FTO issue that we identify, we'll bring that up and elevate that. And any new litigations actually has to be approved by the general counsel and by our CEO.
And
So,
budgeting. So
yeah,
part of litigation
budgeting.
is budgeting. How do you budget for litigation and your work in general?
So we try and predict what we're going to be spending in the next year. Not always easy. Patents maybe are a little bit more if we've already filed on it, because there's strict deadlines of when the next step is and what the costs are. And it depends on how many countries you're going to file in, which is very expensive over the life of a patent. But litigation, we try and we roughly estimate, okay, we have this many ongoing, it's going to cost us this much, or we expect maybe 3 or 4 or 5 more that we are going to, litigate, be the plaintiff. When you get somebody suing you back, you can't predict that. So that's always a challenge. When you enforce a patent, as a defense, the potential infringer will say, well, I don't infringe. And then on top of that, your patent's not valid. So we do get a lot of invalidity challenges, in response to our enforcement actions. And so that's tough to predict if that's going to happen. And so there's always some reserve budget, I think, somewhere. And if that occurs, then, again, we'll go up the chain and make sure we have budget accordingly. And we do govern our budgeting. We do review yearly our entire patent portfolio to rationalize the countries we filed in and whether we can drop some, or any new filings. We have rigorous process on deciding which countries we're going to file in and that kind of thing. So we do have some good governance attached to that. We work very closely too with some key we have fixed fees in litigation. We have milestone fees. We do have a lot of these alternate fee arrangements in litigation as well.
Who negotiates that? Do you negotiate that, or does somebody else negotiate what the fees will be?
A bit of both. It depends on the situation. So, I think our IP attorneys, when it comes to freedom to operate, if we need an outside counsel opinion, we always get estimates. We always talk it through. Litigation, again, it depends. Yeah, not myself personally, we have a separate enforcement group. We work hand in hand though, but they're responsible more for the budget for actually, when we sue somebody for patent infringement. As far as invalidity challenges, again, depending on the country, and we have a number ongoing in China and India. Yeah, we certainly have been, and I've been involved with hiring outside counsel, and understanding their fee structure, and any new case, we will get estimates and we'll hold them to it, and so we can plan and budget accordingly.
Is cost generally the number one factor, or are there overriding factors when it comes to deciding which outside counsel to use?
I wouldn't say it's just cost, no. Actually, responsiveness and abilities and quality are just as important, if not more. And so it is certainly a factor. You know, if I have two equally excellent law firms that we've used and we know, and one is double the other one, well, you know, it depends on the case as well. If this is a bet the company case, we may go even for the more expensive one, because again, it just depends on the situation. But it is an important piece, but it's not the only piece.
Thank you. When you talk about risk, of course, another key factor is the law. And a lot of companies, certainly a lot of lawyers, have been following with interest what's been happening at the Supreme Court and with developments in patent law in particular. So tell us, what are your views on where things are with patent law and any specific area of patent law?
Certainly our Supreme Court doesn't always do us any favors in the patent law area, and they often get involved where, you know, there's been well-settled law for a long time, and now all of a sudden it gets thrown up in the air. We've seen that certainly in the last 10 years with the Myriad decision when it comes to, you know, subject matter eligibility, all these judicial exceptions that they've come up with, makes it, you know, more uncertain actually in practice. And that's one thing companies want. They want a little more certainty on what we can and cannot do. So that's challenging in that. I think, again, just as I mentioned earlier, judges, justices, you know, even the federal circuit, you know, a little less, but, you know, they just don't understand the science and understand the nuances necessarily of patent law. And that makes it much more difficult when they're, you know, trying to come up with some decisions when they don't understand the underlying science. So that makes it certainly challenging. Subject matter eligibility for us is not so critical on the chemistry side. You know, chemical structure doesn't have an issue with subject matter eligibility, but on the biological side, and we do have a very strong growing biological business, and that certainly is challenging there. And I practiced in that area in biotech for many years, so I understand how that is challenging. And certainly on the computer front, right, with the 101 rejections and the subject matter eligibility issues. But, you know, having some more, you know, we want to have clear lines to know what we can and cannot do, and that has been challenging and up in the air many times with the Supreme Court. And then it takes several years later for the federal circuit to figure out what it is the Supreme Court, you know, decided and how to really apply it, and then how the patent office deals with it. So, you know, I know the patent office tries when these decisions come out to, you know, for example, they have great examples on 101, right, on subject matter eligibility. So if your technology, you can, you know, apply it to some of the examples that they have, then those are good arguments to use. And that has been helpful, certainly, is, you know, but that trickles down. That takes time from the original decision to see what happens at the federal circuit, and then to see what happens and how the patent office will deal with it. So that uncertainty is always a challenge. So yeah, if they dealt with less patent cases at some, you know, sometimes maybe better than others.
So two terms that have been mentioned a lot are ESG and DEI. Tell us about what FMC has been doing with its sustainability report, but also reflect on DEI and what does DEI mean at FMC?
So one thing I really do enjoy or you know, recognize that FMC does incredibly well is what we call, you know, our diversity and inclusion. And it's not just talk, they walk the talk, as I would say. If you look at our upper management, there are a lot of women, very high positions, executive VPs who are on the executive committee, on the operating committee. There's even a broader group. So that is actually, they are great models and mentors, and that is attractive to women certainly as well. But it's beyond that too. There's diversity and inclusion is such an important part of our culture that is now part of sustainability. So we have a whole new sustainability, if you want, branch, and a VP of sustainability who is a woman. And they view D&I as a critical piece for our future and to be a sustainable long-term company. And it's not just, women. We have high goals to be able to have, large percentage of women in all areas. The law department as a whole itself has 70% women. So that's a very high number there. But it's beyond that. I think, we have a lot of employee resource groups, huge number. People are very active in them, and they feel very comfortable sharing their stories. Again, we have a large group in the LGBTQ group, and again, I've heard tremendous stories from people explaining their personal journey, and as part of Pride Month and those kinds of activities, and it's not, and these are high level and they feel very comfortable doing it and never feel like they're being retaliated or shunned or anything like that. So, it's a very comfortable environment, and our part of our recruiting, but it's true. We have a great tagline. It says, see yourself at FMC, be yourself at FMC. And I think that's really the culture of, and one of our key core values is respect for people. And they really live it at all levels. And that's really refreshing to see. I thoroughly enjoy that part of working at FMC. I mean, in any work environment, for me anyway, I want to be able to work with people I really like working with, and they're great to work with. And I must admit, our law department is amazing and has changed and grown through the years, and truly is a really great collaborative environment. So and then the other piece is the work itself, right? I want challenging work, fulfilling work, diverse work, and FMC is incredibly fast paced, but it gives us all of that as well. And I have an amazing team that are, just highly experienced professionals, and they're just a great team to work on that we can all rely on and get the job done and move things forward in a very, solution-oriented approach.
Thank you. And I'd say today folks have learned more about FMC probably than in many other places in new ways, and about you as a leader, your journey, and there's much that people should be inspired about. So thank you, Roberte Makowski, Chief IP Counsel of FMC.
Thank you so much for the opportunity.